Hello everyone. Apparently I have gone live according to YouTube. This is Virtual Legality and I'm your host Richard Hoeg, managing member of the Hoeg Law Business Law Firm of Northville, Michigan. And today, because we've had what has amounted to our most successful video in our young channel's history with the video that we put up on Friday, YouTube's MxR Plays, Fair Use, Extortion, and the Muddy Middle of Copyright, I thought I would do what I have done in the past in Virtual Legality, and when one of these videos winds up with a lot of comments, and I think we'll see as we look below, we have 966 comments on this video already, that we would go through and answer those that we can hopefully answer. Like a lot of the things that we talk about in Virtual Legality, some of the stuff in the law, especially when we get into the muddy middle of copyright, as in with respect to fair use and copyright and extortion and all of these issues where a lawyer would sit in front of you and say, well, maybe yes, maybe no. There is going to be a lot of it depends. But though I think I hopefully do a pretty good job talking about the law, breaking down business for you when I discuss these things, it is undoubtedly the case that lawyers will spend days and weeks and months and years researching and fighting over and going over issues like the ones we talk about in Virtual Legality. So as a result, even a 47-minute video, which I know a number of you commented on as, wow, this guy is long-winded. 47 minutes in YouTube is a long, long time, my guy. Can you shorten it? Yes, sometimes I can shorten it, but by comparison to the issues that we're actually talking about, that's not a lot of time. And so there are a lot of areas where maybe I didn't dive into something that you or a number of your fellow commenters were very interested in, or there were areas that were ambiguous or that I could offer maybe a little bit more guidance on to the extent that I have it. That's why I like to do these Q&As. That's why I like to have these conversations with folks. If you are in chat right now, I'm not anticipating a number of people to be watching this concurrently. I essentially got done with a very, very heavy workday here on Sunday, if you can believe it. That's the life of the corporate lawyer. Be careful what you wish for, kids, if you're in law school, if you're otherwise looking into this line of work. It was a very, very busy day on the weekend for me today. But because of that, I didn't announce this. I didn't schedule it or anything like that. If you're in chat, if you've got a question, hopefully I can answer it as well. We're just going to go through this. It's a bit of a proof of concept. This is our first live video on the channel. We're seeing if it works. We're seeing if it makes sense. And if it does work, maybe one day we'll wind up doing a This Week in Virtual Legality, talking through comments, talking through questions that people might have about the videos or other news items that I don't get to see. I do have a day job. I don't look at these things all the time, so there are areas in which I would love to comment on that maybe I don't even know exist, and that you can bring those to my attention. But without further ado, I wanted to talk about some of the comments that are from this video. I want to give the kind of brief, ever so short synopsis of what happened here for those of you that aren't familiar with it. MxR Plays is a YouTuber that regularly does commentary on memes that they find on, I believe, their own Reddit channel. That was kind of delivered to me in respect of the MxR fans that came into the comments. They said, hey, they mostly get it from their own Reddit channel. They do try to vet who owns these things. Sometimes they're successful, sometimes they're not. And they're getting shaken down right here. And so what wound up happening is that this company, Jukin Media, wound up sending to MxR an invoice. It's labeled here as Jukin Media settlement fees. This probably was kind of with a cease and desist letter of some kind that said, hey, pay us this money. But basically they went and they said, hey, we have these videos. You've used these videos. You've commented on them. You've incorporated them. You've monetized them through YouTube. We try to sell licenses to these things. You didn't buy those licenses, and so you are in violation of copyright. You are an infringer of copyright, and we are going to now charge you $6,000 or threaten to strike your channel on each of these videos. You see 4 occurrences here, 3 strikes and you're out on YouTube, so it is a tangible threat. A number of people came out and said, this is extortion. And so I did a video on it. And as I said, it proved to be the most popular video that we have ever done on the Hoeg Law YouTube channel. And as a result, that conversation kind of got people thinking about this. And a lot of other lawyers on YouTube got thinking about it as well. Some before me, some after me. And they each have their own opinions on whether this is extortative, whether it's copyright infringement in the first instance. And if you go and you watch that video, I highly recommend it. I do think hopefully it's clarifying for you if you're not familiar with U.S. copyright law or fair use defenses or extortion on the criminal side, which is really what we talk about. There are a lot of ambiguities. There are a lot of things to discuss. And in my personal opinion, at least with the couple of clips that I looked at, that walks the fine line of whether or not it's actually fair use. There are a number of things that go into that fair use. There's a balancing test that is in the 47-minute video, but suffice it to say there's a lot of stuff that is facts and circumstances based that judges actually go and they look at and decide whether or not something is going to be considered eligible for this fair use defense. And so all we can do as YouTube lawyers and tell you what to look at on these kinds of things is give our own judgment. And in my judgment, at least in the clips that I looked at, they might walk the line as to whether or not enough commentary, enough transformation actually occurred in their videos. Now, that's one side of the coin, right? The other side of the coin, which you'll see in my video, is this extortion? And certainly with Jukin Media following them on Twitter, certainly with them sending something that is orders of magnitude higher than the license fees that they would have charged for the use of the video had MxR identified them and come to them first, then that looks like extortion. We talked about how that looked a little bit like what Michael Avenatti went through last year when he essentially told Nike that he could destroy their market capitalization. And he wound up charged with extortion. Even though if he does legitimately have an issue with Nike, he could bring that up in a lawsuit. He could bring a legal action. He could use contractual means because of the way he was trying to pressure them to kick something out of court, to settle with him, to otherwise advantage himself. Those folks in New York thought, hey, that's extortative. Now, Michael Avenatti is his own kind of character, so you shouldn't take what he does and what happens to him as necessarily an example for everyone that's going through these things. But that's kind of the overview. As I said, I talked about this for 47 minutes. There's a lot more in that video that I put up on Friday, but that's the overview of the situation. And so many people had their own comments on what this all meant, whether or not I was crazy, whether or not there were other lawyers on YouTube that were crazy. So I wanted to talk to you about them just a little bit. So mostly, as I said, this is essentially a trial run. We're trying this out for the first time. We're going to look at these in basic order of best of, or most likes, I guess is what YouTube does here. And then we'll also look at it from some other filters that I've got in the studio program itself. But so the first thing we've got here, 774 likes, is from a YouTuber named Luminous Player that says, requiring considerable amounts of money to even defend yourself from wrongful accusations is perhaps the largest loophole in justice systems. And to that, which isn't a question admittedly, but I've got my own commentary on these kinds of things, I have nothing to disagree with. In all honesty, if you followed Virtual Legality for any length of time, if you followed Help Us Out Hoeg on Easy Allies or anything else that we've kind of done in the media talking about video games or pop culture, you'll know that one of the things that I try to impress upon people, and this includes my clients, is the fact that if you've got a lot of money, you can leverage it against another person, whether that's in contract negotiations, whether that's in the legal system, or the way I usually give as an example of this is through games, right? If you think about a poker game and you think about two people that have the exact same odds of getting good cards, but one has a large stack of chips and the other doesn't have that large stack of chips, the person with the large stack of chips has an advantage. They can leverage that stack of chips to make it very costly for the other player to even play the game. And in so doing, they can increase the worth of their wins and decrease the value of their losses. They can essentially slowly inch up. If they're playing right, if they're doing all the things mathematically that you should do in a poker game, they can ultimately win out because of that large chip stack advantage. And the legal system is no different. And that doesn't mean that you wind up with justice. In fact, I agree with this comment. But it does mean that that's the fact of the matter. That's what you have to kind of know as your state of play. And if MxR is sitting in my office, sitting across from me and saying, what should we do about this receipt? That's the conversation I have to have with them. This is what it'll cost to go to court. This is what lawyers will cost. You could also potentially lose and have those lawyer costs and the loss of your channel and maybe more damages and a whole bunch of other bad things. And yeah, lawyers are kind of known for the parade of horribles that we kind of give to our clients on a regular basis. But that's the truth of the matter, is you have to go in eyes wide open. Doesn't mean you can't go and fight the system. Doesn't mean you can't go and fight the people that are trying to come at you with settlement fees that you think are unjust or unwarranted. It does mean that if the lawyer's doing their job, they have that conversation with you. And it is absolutely a loophole in justice systems. It's absolutely something that reformers of all stripes in all countries are constantly trying to get rid of. I think the U.S. is trying to get rid of that in various ways. We have a whole video in Virtual Legality about the CASE Act and essentially trying to get a voluntary opt-in system for what amounts to a small claims court for copyright violations for things like memes and things like the digital era in the internet. And I certainly am one that thinks that there is a lot of reform that should be coming to the Copyright Act, to the copyright system in the United States, just based on the internet, right? It really hasn't changed to reflect our digital era. And that's really the situation as it stands today. Now, I see here we actually do have a couple comments here. I don't know if anybody's got a question. Would it be legal extortion if it was done outside of the copyright situation? Well, so as we talked about in the previous video, one thing I will say is that extortion is essentially going and threatening somebody for money, for assets, for other things, including physical harm, going and asking for that in an unlawful manner. So to the extent that you have a legal right under the Copyright Act, under your contract, under different things, any kind of legal right, that is going to be at least a starting point for saying it's not extortative, right? The reason we went to the Michael Avenatti story is because it was so special. Every day, law firms and lawyers and in-house counsel and people related to litigation and conflict in a contractual or other setting are going and sending each other letters that say, do this or else I'll sue you. Do this or else it could be much worse after I sue you. And so those all have to walk the line. And so when we evaluate something like this, that's the standard state of play. You have to kind of evaluate it in that context. That let's assume, just for purposes of the argument, that Jukin Media has the rights to the copyrights that they're asserting. They have those rights, and they can go forward and put a legitimate lawsuit together. Do they have the right to then threaten that lawsuit and ask for money in advance? Yeah, that's a settlement negotiation. That is standard operating procedure because the legal system, if you can believe it, doesn't have enough resources to handle everybody's conflict. So they are constantly advocating for people to come up with ways around it. So please settle. Please don't put all this through the courts if you guys can come to an amicable resolution. So the legal system in the United States and elsewhere wants to advocate for these alternative dispute resolution mechanisms. Mediation, arbitration, settlement, absolutely. And the truth, kind of the hidden truth of civil litigation in the United States is that almost everything settles. There are exceptions. There are different areas of law that isn't the case. But almost everything on a corporate basis, on a commercial basis, settles, with very few exceptions, often that make it into the news. But because of that, you have to essentially allow for those kinds of do this or else I'll sue you letters. But if it goes too far, if you start to leverage what are called misrepresentations, even if they had the copyrights, there's no court on earth that would give them $6,000. And I can't answer that for you. But if that is the case, somebody could find at the same time that $6,000 was extortative. And you combine it with the fact that they're threatening your channel when they have other avenues that could conceivably get them the money they are looking for, such as just a copyright claim rather than a strike, then you start to paint a picture of a bad actor. And that's what I said in my video on Friday is Jukin Media does not look like they have clean hands on this, okay? When I finish my video and say, well, it walks the fine line on fair use from the MxR side, I think that's true. But I do think that Jukin Media walks the fine line on extortion and really leveraging some, if not misrepresentations, at least taking advantage of people's lack of sophistication on legal matters that I think could be looked at askance by the right court. Now, whenever I say that, and we're talking about it, we're talking about judges, we're talking about people, we're talking about folks that you have to kind of try to read their mind as to how they will wind up deciding a situation like that. But that's a good question, and I thank you for asking it, Absol Story of Fiction. And I appreciate the commentary in chat. I'm actually surprised at this many chat folks, so I really do appreciate it. It looks like this experiment is working out so far. We've got a comment here that says everything Jukin Media is doing sounds hella illegal, which it might. I think what it sounds like is shady. Right? It sounds like a business model that I think a lot of you that are following this channel wouldn't want to be engaged in. But there are a lot of business models and even what we might consider shady business models that aren't illegal. One of the things I like to say in Virtual Legality and elsewhere is that what is legal isn't always right, and what is right isn't always legal. And so you have to kind of take that into consideration. When you watch something like Virtual Legality, I'm trying to analyze things based on the current state of play of the law. And there could be reforms that are needed to kind of talk about this licensing regime. However, I would say, not in Jukin Media's defense, but in defense of the concept of going out and licensing videos that become popular, there is a business model that could do that and look like a good overall for the economy or for whoever, right? That there are people there that have these videos that wind up getting millions of views on Twitter or Instagram that really could use a little bit of money and don't know how to go through that process, so they wind up with nothing. And there could be a good actor in the industry that essentially says, okay, yeah, let's sign you up to a license. We're going to do this the right way. We're not going to go and we're not going to threaten people in various ways, but we're going to tell them about what we've got. We're going to make it easy to search on our site, maybe by image recognition or otherwise. And we're going to get these people that have made these popular videos some money. And at the end of the day, I think that's potentially a good thing. And no, I don't think Jukin Media is operating with those optics right now. And so I don't think it sounds illegal necessarily, although it walks the line, but it definitely sounds shady and not the kind of business that I think a lot of people would like to be involved in. I wonder why Jukin never goes after Reddit itself. Well, the answer to that question is that Reddit isn't the provider of the information. As a website, and I think you've probably heard this around the internet or elsewhere, and there's a lot of misconceptions about this, but the Communications Decency Act Section 230 basically says if you run a website service, you are not responsible, you're not liable for infringement and other various bad things that are put up on your website by the users of that website. So that protects the Reddits of the world. It does mean that Jukin could go after, if they do have legitimate copyrights to these various videos, they could go after the actual Reddit user if they can figure out who it is that put up the video. That's somebody they could go after. But like I said at the start of my video on Friday, the big question, if you're the Jukin Medias of the world, is where can I go get my pot of money? And a number of people entered into my comments, and I thank them for it, saying, hey, yeah, MxR has a lot of subscribers, and they have another big channel about mods that they've actually demonetized because of some other trouble that they got in. But they have a lot of subscribers, but maybe they're not making a ton of money. And I don't disagree with that. I don't know how much money they're making, how well they're doing, how much they get demonetized or else. But if you are sitting there, and let's say I was in-house counsel at Jukin Media, and you're going and evaluating who you should go after, there's probably a threshold number. Let me go look at people that have 500,000 subscribers or more, because even if they don't have necessarily, get rich and go away money, they have enough money to make it worth my while to send this kind of letter. And that's what you're trying to do if you're a company like this. You're trying to establish, where's my bottom line? Where does it make sense for me to spend the time to go figure out who these people are, how much money they have, what kind of videos they're running, how much I can go get out of them. And that's, I think, really where you start to have these equations, this calculus, is, okay, 850,000 subscribers sounds like they probably do have enough money. And I'll say this from a legal perspective, and this isn't necessarily brand sales for myself. It could be any lawyer that you like or that you know or is in your area. At some point, if you get popular enough making content and putting it publicly online, and I don't know whether that's 850,000 subscribers or 1 million subscribers or 300,000 subscribers. At some point, it probably behooves you to kind of transition your mental scape to thinking about it as a true business and worrying about liabilities and insurance and the things that true businesses worry about that are annoying, that are boring, and that you might need a lawyer for or an accountant for, but that the reason these businesses worry about those things is exactly because of the types of things that MxR Plays is now finding itself dealing with. If you had some kind of errors or omissions insurance, if you had some other thing that was a product that you could pay a little bit of money into to protect against these kinds of things, that could be helpful to you. And certainly having a vetting process that is maybe a little bit more formal could be helpful to you. And I think there is a point in time, certainly if you're at 10 million subscribers or something, that you should be spending that small amount of money to get right and try to protect yourself as much as possible. Maybe it's not 850,000 subscribers, but it is something that I think should come up at some point in time. Let's see here. No one makes Genie cry. Even if it's not clear extortion, it's definitely a scummy business practice. Nothing I disagree with. Worst thing about all this extortion is that MxR doesn't even get ad revenues for most of his videos. As I said, that was mentioned to me a number of times in the comments, and that's a fair complaint. It is what it is, really, in respect of that. They saw 850 and they thought, yep, I think that's probably who I can go get money from. One of the other kind of facts that I didn't know going into my Friday video, but that was brought up to me a number of times, is that this is actually another step in Jukin's process that they apparently at MxR paid for some other video clips, the $49 licensing fee, and then Jukin came back with this. One of the things I will say about that is if you go and you talk to a lawyer on these things is you have to be very, very careful about essentially what you admit to when you make that first step to what you're paying for, because people can go and ask for rights that they don't have. They can go and ask for these things essentially as a feeler, as a test case for going for the bigger ask, the $6,000 or what have you. And I think you do have to be careful about that. And if they sat down with a lawyer, they might have said, how legitimate is this claim? If you go forward in this direction, something like this, the $6,000 bill might happen. How do you feel about that? There isn't a great protection for that if you don't send in that money and also get some kind of contract with it. A general release of the liability for your existing videos, perhaps a general allowance for future use in certain cases or in certain ways. That's the kind of thing a lawyer can help you with and can probably help you with for maybe half of the big bill of Jukin, if that. If everybody's on board with what should be a fairly simple document in simple terms, that is the kind of thing that you can maybe get some help with from a lawyer or even just from a business professional or business party. Let's see. So basically all laws are, it might be, which means that the laws are made up so that the courts can get money. I don't think that it is for court funding. I do think that in general, there are a lot of laws, especially in the United States, and I'm most familiar with the United States laws over European laws and some other jurisdictions' laws, that are built to allow for a great degree of judgment on the part of either agencies, as we saw with COPPA, right? We've talked a lot about COPPA, and we've talked a lot about the Federal Trade Commission and them retaining the right to essentially decide when a website is directed at children or not. But also those instances where a court can come in and balance things, right? Ultimately, the balancing test for fair use exists because it's in the statute, as we talked about in Section 107, but also because the basic premise was we don't know what we don't know. And the issue with laws is always if you draw a clear, bright line, you run a significant risk of either under or over inclusion, making criminals out of people that shouldn't be or not including people that should be criminals. And because of that, there is a large amount of law, a large body of law that really tries to be a little bit vague on the premise that the judges are going to be paying attention, they're going to do their job right, and they are going to try to understand where the justice lies in these various situations. I think that is a laudable intent. My issue with that kind of practice in law is that it means that when we're talking about things in virtual legality or we're advising clients, we're talking about fair use and copyright and things of that nature, it is very, very difficult to advise people, right? We don't have a bright line. We have to evaluate everything on a facts and circumstances basis, and that leads to a lot of people not knowing what to do, and it leads to a lot of well-meaning, law-abiding citizens, YouTubers and elsewhere, trying to essentially avoid the line entirely, right? You look at MxR, and some people said, hey, I don't think they're acting immorally here. There couldn't be anything I agree with more, at least as they describe their situation and what they've tried to do. And if we assume that's all true, just like we've assumed Jukin stuff is true in the past, if we assume their story is true, then the nature of the thing is they were trying to be law-abiding. They maybe got burned by showing that they would enter into these certain contracts. They didn't do it with a full legal release and things of that nature. And so they were looked at as easy marks. And this story will be looked at by other YouTubers, other people trying to enter into the content space and say, I don't even want to come anywhere near the line on this kind of stuff. And to some extent, society will have lost something. I know there are people in the comments that say, hey, I don't watch reaction videos. They're terrible. And you don't have to watch what you don't want to watch. You don't have to watch what you don't like. Some people do like them. Some people get value out of them. And I think there is value to be had from them. My commentary on their clips were just that they maybe weren't transformative for purposes of the Copyright Act. But that doesn't mean that there isn't a lot of good stuff that they do, and there isn't a lot of good fans that they have and people that like what they bring to the table. And if you imagine that the MxR2 of the world saw this story, saw what happened to MxR, and just decided to not quit their job, not YouTube at all, and never do this thing that would have brought joy to 850,000 or 2 million people in the country or in the world, I look at that and say that's a loss. We should be able to figure out a way through the Copyright Act, through the law, through contract, or otherwise to go and bring these two entities together. Maybe Jukin Media has a legitimate right. Maybe MxR walked up too close to the line. Let's figure out something that gets everybody where they need to be in the economy, in the law, and elsewhere, so that you don't have these people that would otherwise do this thing look at Virtual Legality, watch this video, maybe watch the video on Friday and say, man, that is too tough for me. And I like Rick, but I don't want to pay him legal money, and I don't blame you for that either. And so I don't want to walk up to the line. I don't want to get involved with copyright issues. And so I'm just not going to do it ever. Continuing with this, let's see what do we got. They should not be allowed to do this to MxR or anyone. MxR even offered to let them view the videos before they posted to YouTube. And Jukin, they, said no. They just want to wait and extort. It is not even about copyright. So I saw this brought up in a number of comments as well. And this was the notion that MxR said, okay, Jukin, we really don't want to walk up to the line. We really don't want to infringe on your copyrights. Can we make a video and then submit it to you? You can review it and you can tell us what is wrong with it before it even goes up so that there is no infringement. That would do us a solid, and we would make sure that you weren't burned on any license fees that you would otherwise like to collect. And they said no, apparently. And I said in my comments, I said this in a couple of places while talking about this video, that doesn't surprise me. So again, you got to put yourself in Jukin Media's shoes. And if you're Jukin Media, you've got these folks asking for you to review their YouTube videos. And if you don't find something, you've essentially waived the right to come after them later, which is what MxR is looking for. But you're not employing people to service MxR. You're not making money on that. And you could potentially have other exposures to liability. So what I said in my comments, and some people yelled at me for this, and that's fine. You can absolutely disagree. I can understand wanting the world to be this way, is that they don't have a legal obligation to kind of bless your videos. So you put them up and you go and you see if you infringed on their rights. That doesn't change the facts of this case. The fact that you went and you offered to get it blessed and they refused to do so. I think any court in the country, probably in the world, would say, hey, they don't have that obligation to you. You could potentially enter into a contract of some kind that said, hey, we'll give you a little bit of money to check this out, to bless it. We really appreciate that. But otherwise, you don't have the right to essentially go and take their services, and they are free to say, no, they don't have to do that. And that's the situation there. I can totally understand why, just kind of outside of the contractual basis, outside of corporations operating like a Jukin Media or like MxR really is acting like as an entity in this case, I can understand why you say, hey, that should be something that should be allowed, and maybe Jukin could do something like that. The other kind of secondary reason I would recommend them to not do that, were I their counsel, is that you don't know exactly when the next person's going to ask. And if everybody asks, you've got a real problem. And there isn't a great bright line for you to say yes or no to outside of a contractual relationship. And that contractual relationship would probably be priced higher than the licenses to begin with. And I'm not saying this as someone who likes how they've operated. I mean, that's one thing I think that gets lost in the wash a little bit, is that I don't like how they've operated here. This isn't how I would recommend that they operate. It wouldn't be what I would recommend if they were sitting in my office and asking me for advice on what they should do and how to operate. But it is what they've decided to do. Let's see. What do we got next? A lot of people that are really big fans of MxR. One of the best ways to help YouTubers is by commenting, liking, and sharing. I always appreciate that. Not really a question, but I do appreciate it. Hoeg Law, I'm wondering about this. Would it be a good move to have MxR's fans come together and crowdfund a legal defense, bringing this issue to the court? And I think I can actually pull up my response to this one. Yep, great. What I wound up saying to this is it's up to the fans, obviously, right? If somebody's going to ask you for money or you're going to put in the money, then that's up to you. The issue that I have with this particular case is, yes, I think Jukin Media is acting with unclean hands. I think you might be able to get a judge to say that, could get them into trouble. But unlike some other things that we've seen kind of in the past with Jukin, and I'm going to bring that up as part of this video because that did come up in a couple of comments as well. If we get to that directly, that's fine. Otherwise, I have the tabs ready. That they've been to court before. And in this particular case, it looks like Jukin Media has a stronger case. Just from my reading of the case before and the clips that I saw of MxR's videos in this specific instance, it looks like Jukin Media has a stronger case than they did against what was called Equals 3, LLC. And so the situation is always this. do you want to fund and get up and lose? MxR, maybe that's not as specific to them. So if you just love MxR, you want to fund them, you want to give them a legal defense fund, you just want to back them, don't blame you, go for it. I'm never going to say no to people engaging with what they love, engaging with the legal system. These kinds of questions, absolutely not. However, if you want to fund this because you want to effect some kind of copyright reform, you want to get it up at the top of the litigation level because you think you're going to win a big victory, this is probably not the test case to do it. I don't know if any of you follow kind of constitutional law or other areas of law, but one of the issues that constantly comes up is finding the right plaintiff, right? You want to go and you want to challenge a statute and the constitutionality of a statute. Let's say it's AB 5 in California, which I did a video on, which essentially makes almost all contractors into employees. And there's like 6 lawsuits that have already been launched against it, and it'll be fun to watch for a lawyer like me. But they had to go and they had to find good plaintiffs, sympathetic plaintiffs, empathetic plaintiffs that had very good facts behind them so that they would maximize their chances of absolutely winning that court case. And the issue is, I don't think this is that great of a test case, right? This is an area where you could actually have the judge spin around and say X, Y, or Z are not fair use. And if that gets into especially a non-appealable order, like it's gone all the way up the chain, which I doubt it would on something like this, but even anything that's public and is precedential, whether that's in California or elsewhere, you have the risk of getting something in words that says exactly the opposite of what you want it to say for how you want these channels to operate and the rights you want these channels to have. So I said, look, I wouldn't say anything against engagement, but if you were to ask me personally, would I fund this? And let's pretend I was an MxR fan. I didn't know about them before this, but let's pretend I was a diehard fan. I would still look at this and say, I don't know, because I do think it runs the risk of creating a bad precedent for you. And I never want to see that happen, especially from people that are motivated and want to see good things come out of this. So crowdfunding is a very useful tool. It can be a very useful tool. If you want to back them up, don't blame you one bit. But I look at it as a lawyer and I say, this runs the risk of some significant issues. Continuing with what we've got here, and then maybe we will switch over to the things that I know I've commented on because I think those are ones that I think we really have some questions to answer. They talk a little bit about the pricing here. Isn't the extortion point about Jukin not using the content claim but threatening with copyright strike instead? Leveraging a system that destroys their business without even going to court. So this is an important one. This came up in a number of comments as well. To the extent we assume Jukin has the copyright to these videos, and I know that's an assumption and we all have to accept it, and we don't have to assume that if there's a lawsuit going forward, but just for purposes of this conversation, if we assume Jukin has that copyright right, there is nothing in the law that says they can't use the full extent of their legal rights. And YouTube has the ability for you to go and make a strike rather than a claim. And so it's not specifically problematic from a legal perspective if Jukin does have the intellectual property rights that they claim to have for them to go to YouTube and say strike instead of claim, and let's end this channel right now. Now, that's the legal point in its vacuum. However, when you combine it with kind of following them onto Twitter, following them onto their various social media presences, kind of making all of this public and making it pressure from all these various directions, it does at least contribute optically to the point we were making earlier about misrepresentations and pressure to settle and pressure to go get this $6,000 that the law might find unwarranted. So it's this muddy middle gray area. If we assume they're fully within their rights, it's not an issue. If they are in this gray area, if a court could say, hey, those damages aren't realistic, or hey, you really didn't do a proper fair use analysis. I don't think that's the case, but a judge could disagree with me, certainly. If the court came to that conclusion, then you would look at this, especially in retrospect, and say, wow, you used every tool in the tool belt to really make their life a living hell. That starts to look like you are unlawfully threatening somebody with misrepresentations about the strength of your actual position. So that's kind of the full answer to the, does their threats of strikes add to the extortion? It's yes and it's no. And I apologize in advance for those of you who aren't used to talking to lawyers. Sometimes that's the way the answer kind of works. We've got some people referencing the email, which there are other videos on that talk about those. One of the things I did want to mention before I got to the end of this video is that Leonard French and Lawful Masses, and I think a number of other lawyers and lawyer folks on YouTube have taken this up. I highly recommend checking them out as well if you haven't already. I think Leonard French and his team do a good job. They also analyze the earlier court case, which we're going to talk about towards the end of this video when we wrap it up, which probably won't be too long. I didn't necessarily want to go all night on this, but that he did a great job talking about the previous case, talking about these issues as well. And he and I think, agree a lot and don't necessarily agree on some of the facts and circumstances analysis. And so that's kind of the way it is with lawyers, and certainly the way that you have to think about all these things is trying to adjudge kind of percentage chance of success or loss on these various things. We've got some people that are offering various types of reforms and things of that nature. And I think that's basically it from the top end, just based on the likes that I wanted to talk about. I also wanted to pull from the comments that I had commented to, because I think there are some good ones here. There are some people telling me that I should give legal advice to them in the video, which I will never do. I know there are some lawyers on YouTube that do that. In my opinion, that's an ethical bar that you really can't give formal legal advice to people that aren't your clients, because you don't know the full nature of their facts and circumstances. So while I will kind of go up to the line and editorialize a bit on how I think maybe things should be handled from various parties, I will never give formal legal advice. I apologize for that. I believe that particular commenter wants to punch me in the face. I can guarantee you, you are not the first, and I doubt that you will be the last, whether in real life or in internet life, to want to do that. So I respect that opinion. However, I won't be making those suggestions. This comment I did want to talk about a little bit because I like this. This was only from a couple hours ago. I do wonder what would have happened if they simply did just pay the $49 for the clip. Now, there's actually a factual question about whether that $49 is actually legitimate. That's what Jukin offered they could have paid, but it appears that there's a difference between various monetized, non-monetized size of your channels for the license fees, what you would expect from a Shutterstock for viral videos. So maybe 49 isn't the right number, but I think we can assume from this comment, whatever the right number was that would have gotten them the license rights that Jukin is claiming that they should have had. It does make me think if they paid the $49, Jukin should have also gone in and said, you made more than the $49, so now you owe us $1,500. Another thing is, what happens if they simply ignored the notice of settlement fees letter and didn't bring it up? Because this thing does happen to some companies as well, and usually when they ignore the threats, the other company just goes away. And my comment to this was, absolutely, we talked about this in the video. You can absolutely ignore it and call their bluff. And they have a lot to lose too, after all. If you take them to court, or if they take you to court in that particular fact pattern, they could get a poor precedent that also comes through the court system that would hurt their ability to do this entirety of their business model in the future. They would have to be assessing that particular issue as well. It's just a matter of whether you think they are serious or not. And certainly folks that aren't regularly dealing with litigation and contracts and business folks in suits and mean lawyers that call them up and yell at them on the phone, certainly that is the area where you can just have this kind of pressure practice, have you make bad decisions or have you make decisions that are not in your best interest. And that's one of the reasons that I do recommend when you have a situation like this, you go and you try to find a lawyer that works for you. And a lot of lawyers in your area will probably have a chat with you about your situation and do something on a relatively economical basis. I say that from the position of a lawyer, so economical for law firms and lawyers, maybe not economical for kind of day to day. We're not talking about McDonald's prices, but that lawyers often go and try to help folks that need it. You know, Hoeg Law started essentially as an offshoot of a 13-year big law practice at the biggest law firm in Michigan, because I wanted to work with entrepreneurs and smaller businesses more, to have a little bit more price flexibility to do these kind of things, to talk to you all on YouTube. And so there are lawyers out there that have made the similar decision, and I highly recommend seeking them out if you get into a similar position, because there is strategy, there is game theory, there's games playing. And yeah, it's helpful to have a law firm on the letterhead to go and shout back at them, whether on the phone or with letters or what have you. Let's see what else we've got here. One of the things I said on Friday was it doesn't make sense for me to poke them by putting their video clips up in my video, which absolutely makes sense. Some people called me on it, said I believe somebody called me a coward. And what I would always offer is lawyers, and maybe not me personally, but as a class, are probably the most risk-averse people on the planet Earth. And so you look at it and you say, hey, I can comment on this without including the video clip. Then that's what I'm going to do, because there's no reason to take on that risk, because there's no particular reward. So I made that comment. Again, I respect the person that calls me a coward. That is absolutely fine. But I didn't want to do it, and so I didn't do it. But what they added in this comment was, we have 829,000 sticks. We poke what we want when we want, says the internet. And I said, absolutely. Sure, that makes a ton of sense. If you are not one individual, if you're not going public with a video or on your YouTube channel or elsewhere, you can absolutely bell that cat. And if you didn't watch the video earlier in Virtual Legality, or if you're not familiar with game theory, bell the cat is the concept in game theory or public choice or wherever else you might find it, that there's something good to be done, but the person, in this case the mouse, that does it, or the mouse that does it and his buddies, are probably going to get eaten. But the overall good to society is more than the 3 mice that are going to get eaten is worth. And so, yeah, if you've got all these sticks, if you've got essentially this kind of diffused liability, that can be a situation where you can bell the cat. And I highly recommend it. If you're interested in it, engage on this stuff. Absolutely. I never want to dissuade anybody on those kinds of things. We've got another comment on what we already talked about with respect to the free service and kind of checking on the videos. Got a few people insulting me, is what it is. We already talked about the fact that I would not question the morality of MxR on this. Everything that I have seen from them indicates that they really do want to be law-abiding. That's always when my heart goes out to people. That's when my heart goes out to people when we were talking about COPPA. It's when my heart goes out to people when we talk about this kind of stuff, is that the worst thing the law can do is take the law-abiding and have them foot fault or otherwise make them worried about operating in society. And I absolutely do feel for them in this circumstance. It's why I call for copyright reform in probably a dozen videos in Virtual Legality. I really think the internet and the internet era is something that lawyers and legislators really do need to take a look at. They talk about the fact that MxR maybe doesn't have the money. That's fine. Someone asks me, so this is a pertinent question, as for balancing factors, doesn't intent count? So one of the things that I don't think I mentioned in terms of a term of art in the earlier video is that copyright infringement, with very rare exception, is a strict liability offense. That means that intent doesn't matter. Most laws, especially criminal laws, have what is called a mental element. What we might say is mens rea, if we're being fancy lawyers about it. But that is the concept that you have to have an intent to break the law, or at least a willful negligence about the law, things of that nature. There are different standards for intent. And copyright infringement basically says the opposite. It says the copyrights exist as this exclusive bundle of rights held by the copyright creator, the copyright holder, and if you go and you breach one of those exclusive rights, you're in trouble. And then fair use and a couple of other things come in and say, well, it doesn't count as infringement if X, Y, or Z. And so that balancing test is designed as a defense, but it doesn't actually change the fact that intent doesn't matter, except for the most kind of extreme circumstances, innocent infringement and all this other stuff that doesn't come up in this case as best I can tell. We've got some very nice people saying nice things about the length of the video and how they didn't want to watch a 47-minute video, but they did anyway, which I always appreciate. We just talked about the extortion question. We talked about the fact that they don't have to check for other people. We talked about MxR's other channel. We talked about reform briefly. So I think this is going to pretty much conclude what we've talked about. The last thing I did want to mention was, and again, Leonard French and Lawful Masses discusses this, goes over this at length. I don't want to go over it at length, but a number of comments, a number of people did bring up the fact that Jukin Media has been in a lawsuit before. They were in a lawsuit against Equals 3 LLC that actually went the other direction. They threatened Equals 3 sued them back, a whole bunch of stuff. And there's a couple of things that go into this. I'm going to read you a section that is my indication why I think that maybe the MxR case isn't as clear-cut as this one, but also the fact that this didn't actually go through a full judgment. All we have on file here is the order granting in part and denying in part Jukin Media's motion for partial summary judgment, an instant win on their claims. And that got denied in some significant areas, but it didn't go all the way through order. There was a settlement. It went away. And like I said, most things get settled when we're talking about commercial contracts. However, there is some language here that is worth kind of going over. I do recommend checking out the Lawful Masses video. But one of the things I flagged, and I probably should have highlighted this first like I do in my other videos, is the nature of the transformation here. They said, reading cases on the fly is fun. It says, nevertheless, even if Equals 3's episodes are not parodies, the episodes comment upon or criticize Jukin's videos. You say, all right, okay, hey, that video of the volcano, maybe commentary, maybe the facial expressions. There is a box added to the video. Maybe that does the job. You might be right. I think it's a problem because it's not that much. They go on in this particular case to say Equals 3's episodes directly respond to and highlight humorous aspects of Jukin's videos. The episodes do so via the host's reactions to the videos, jokes, narration, costumes, and graphics. So, okay. So jokes, narration, costumes, and graphics. So we're getting into a little bit more of an area of transformation. Graphics, costumes, that kind of thing. The host's narration does not simply recount what is shown in Jukin's videos. So if you remember, if you saw my video on Friday, one of the things that I said was their particular video on that, which was a shortish clip, I thought probably, you could argue, used the heart of the copyrighted material. Again, if we assume Jukin has those rights. And they mostly don't say anything over the video, and they don't say much of anything after the video. They do have some facial expressions while it happens, but mostly it's a wow, look at that volcano explode. And so I look at this and I say, well, if we're just using this standard, and we don't have to limit ourselves to this Jukin order of summary dismissal and things of that nature, we don't. But this is useful because Jukin was actually involved in this case. The host's narration does not simply recount what is shown in Jukin's videos. I think that in this particular instance that I analyzed on Friday, it probably did. Instead, the host makes comments about Jukin videos that highlight their ridiculousness by creating fictionalized narratives of how the events transpired, using similes, or by directly mocking the depicted events and people. Equals 3's episodes also repeat portions of Jukin's videos multiple times within the same segment. So, like I said earlier in the video, and this is just one piece of this that I wanted to highlight. If I remember how to archive and do all this stuff with this first live video, I will add this link to the description of the video so you can read it yourselves. But when we talk about funding a litigation, this is the kind of thing where I think if you went all the way to the end, you might get language in a paragraph like this that speaks exactly the opposite of how you want it to speak about something like MxR Plays or the situation that it finds itself in with Jukin Media. And that isn't to say that all the clips are that way. That isn't to say that even the clip that I looked at most specifically on Friday would end that way. Again, we're guessing as to how a judge will react to these kinds of things. However, in these 4 specific instances, it might be the case, even if they are otherwise parodies and everything else, in every other instance, that they might fall afoul of fair use in these specific areas. So while I think this is useful, I think you should check it out if you're interested in this whole story, and definitely check out the Lawful Masses video, which I checked out yesterday. It is the area where I think you have to be careful about setting precedent that is not to your advantage at the end of the day. So I think with that, we've mostly succeeded at our first live broadcast here. I see somebody actually saying at Hoeg Law, which is cool because it jumps out at me. So anybody that definitely wants to get my attention, do that at Hoeg Law thing because that appears to work. It's orange on my screen. It says MxR does the exact same thing that H3 does. I assume that's Equals 3. They add more humor to the memes they review. They make their own content by doing so, kind of how H3 won. Yeah, no, absolutely. I think there are circumstances where any given clip, that could be the case. I can only speak about the clip that I saw where I looked at that and said, yeah, if I'm Jukin, that's the kind of thing that I would identify as potentially problematic, where they don't really say anything, there is no narrative, they're not highlighting anything, they're saying wow with the video and moving forward. So absolutely. Absolutely, that analysis is useful on transformation. It's useful on determining fair use. It's useful going forward when you're kind of having these conversations about MxR Plays or elsewhere. But that means that every specific video clip, every specific time that they kind of interact with a Jukin Media clip or anybody else's clip, that's the analysis that they have to do. That's the analysis that they have to go through. So it's a facts and circumstances test. It's a facts and circumstances based on a balancing test of a judge you don't know. And I totally understand why people say that's ridiculous as a law. It's ridiculous as a way to drive my business and how I'm going to act. I understand. I agree. I can only talk to you about what it is, right? I'm getting a little bit more clarity. H3 isn't E equals 3, but pretty much same thing idea, okay? The clip they watched before Jukin's clip in question was a particularly unnerving one. You could see the girl was still shook from that when they played Jukin's clip. All fair, right? All fair, and probably things that you would bring up in the claim that you make against Jukin. If you were winding up in a litigation, whether they sued you or you sued them, if that was the argument, you'd be saying all this sorts of stuff. You'd be saying it's 13 seconds out of a 20-minute video. You'd be trying to establish why that 13 seconds actually worked with what was before and after it in a way that was transformative. You would certainly argue that the facial expressions are transformative. I can only give my opinion sitting here from afar that that's the kind of thing that is walking the line more so than if they had done an entire skit with the video in the middle that had them in costumes and had graphics pointing things out and slowing it down and repeating it 6 times, right? And I'm not saying that's the type of YouTube video that you should like and you like this one better. That's fine. I have no problem with that. I like that better too. I don't like all the crazy YouTube stuff. I'm a little too old for it. However, it does make it more transformative when we're analyzing things for copyright law. Is it legal to ask for an amount of money literally outside the court since anyone could ask for more? Yes-ish. They probably asked for a little much in my opinion. They already paid the $49 fee. So as I understand it, this actually came up in a number of comments as well. As I understand it, the fee that is charged by Jukin Media is per clip. And per clip for a specific use. It's the same way you might go to Shutterstock. They compare themselves to Shutterstock a lot. But you go and you get rights to a specific image. It's not a library right. They actually offer in their comment to that video and in that we talked about on Friday in their tweet to offer a library license if MxR wants to negotiate one with them, which maybe is not legitimate, maybe it is. But as I understand it, the $49, the $99, whatever that would be per clip. And so Jukin could always go and yes, they could buy 4 clips, but if they used 4 different clips, they could go and try to get that money for the 4 clips that they didn't buy the license to. So that's important. That's good information, but it doesn't get you out of the next infringement. And if they bought the $49 one and it wasn't the right license, yeah, Jukin could again be acting shady. I really don't doubt that at this point. But if it's not the right license and they weren't allowed to monetize using that $49 license, et cetera, they could still be called on for infringement. And yeah, maybe Jukin Media is acting like shady mobsters. Maybe you can hate them, but it doesn't make what they are doing necessarily illegal. Hoeg Law, can be argued that the reaction video is not a replacement of the original material because the audience is mainly consuming the reaction video for the reactions. Yes, that goes to the 4th quality of fair use, right? We talked about the 4 concepts in the balancing test, but the last one is effectively use upon the potential market for or value of the copyrighted work. And so this is one that I gave to them, that there probably wasn't a loss in potential market value for their use of the clip, that this clip was only being used for these people's reactions. As a matter of fact, the YouTube video that we found didn't mention a volcanic eruption at all. It mentioned a different video. So this wasn't something that somebody could go and say, I want to see that volcanic eruption, so let me go find it here. It wasn't a good substitute. I think they probably win on that balancing factor. But the other factors come into play as well. Transformation is really, really important. And I think that they have a difficult case to make in respect to transformation. Can't this issue be resolved if MxR deletes the videos he's being billed for? It might be resolved from the YouTube standpoint. If they're deleted, I don't know that you can have a strike on a video that doesn't exist. They might be able to contact YouTube for it. It wouldn't work in an automated system. It wouldn't change the fact that there was an infringement. Again, if we just assume that Jukin Media is correct, once an infringement occurs, it occurred. And so just getting rid of it after the fact doesn't mean somebody couldn't come after you in court, couldn't say, yeah, they got rid of it, but they already got this amount of money from monetization in YouTube that was in violation of our rights, judge, and so you owe us X, Y, or Z, and they should have paid a settlement. So deletion doesn't necessarily get them out of Jukin Media's crosshairs. It probably is decently successful at getting them out of a YouTube problem and lost the channel entirely. What if Jukin bought the rights after MxR produced the video? How would that change matters? Well, it wouldn't necessarily change matters. So the way copyright works is that it attaches to when the creation is made. And then the maker of that creation has a copyright. And then if we assume what Jukin Media is telling us is true, that creator then licensed the right to Jukin Media, even if that was after MxR had used it, and this would certainly be a part of any story that you tell in litigation, it wouldn't mean that there wasn't an infringement. It would essentially mean that they infringed on the original holder's rights, and then Jukin Media bought the rights to go and sue over that infringement. There's a whole bunch of stuff with registration and other areas of law that come into this. I'm simplifying this for purposes of YouTube video discussion, but while it might be an interesting wrinkle, while it could potentially be helpful to the story they are trying to tell, especially that they have the clean hands and Jukin Media has the unclean hands. So when I use those phrases, I'm talking about equity. I'm talking about equitable jurisdiction of courts to essentially decide things based on fairness and justice rather than on the strict legal language of the statutes. That could all go to that story, but it probably isn't just a silver bullet to ending the litigation entirely. There is a rumor Jukin licensing stolen content. Yeah, absolutely. If you haven't heard it in this video or the video on Friday, we're assuming that they have these rights. If they don't have those rights, that's an entirely different conversation. If they're wrongly dating things, if they didn't enter into these licenses correctly, if they are actually intimidating the people that entered into the licenses, if they're not actually fulfilling their obligations under the licenses, et cetera, et cetera, et cetera. There's a bunch of things you could start to attack on the business model. I can't opine on those because they're all kind of speculative and guessing at what the Jukin Media internal landscape might look like. But if they have all those issues, if they stole the content or otherwise, that is exactly the kind of thing that could come up in a litigation stand. Here's a good question. Why Jukin Media didn't go to court, but go directly to MxR and insist to pay so much money? Isn't it a court business to satisfy such requirements? No. Actually, the first step is always go and ask for the money or go and ask for your redress. Sometimes you've got somebody that's violating your contract and you just want them to stop. And so you send a cease and desist letter that says, hey, here's the contract term you're violating, stop. But you don't just bring it to court immediately. And as a matter of fact, in some cases, the court will actually look at a situation where you come to court and say, hey, did you actually try to ask them to stop this? Did you actually try to ask them to settle? Did you actually try to ask them to not come to court on this? And that can be a bad thing if you didn't do that. If you didn't try to use all methods outside of the court system to get this resolved, a judge or a court can look at that in a bad way. And so as a matter of fact, you want to go and do this. As a for instance, I think if Jukin Media had sent a thing that said, hey, guys, those were our videos. Here's a bill for the licenses you should have paid for, $50 a piece. I don't know that this would have the same kind of visceral reaction from people, and I don't blame them. You know, $1,500 is many orders of magnitude above the $50 they claim would have been good enough, even though some people say that it might not be under their license terms. But if they had gone and asked for that, I think everybody would be saying, yeah, that's a better use of the court's time and resources than just taking them to court straight up for $200. Hoeg Law. What happens if Jukin Media acts on the behalf of the IP holder instead of owning the IP outside of the contract? Does it protect the IP holder? I'm not sure I understand that one specifically, but the way these things work is that somebody that makes that video of a volcanic eruption will presumably license all or a portion of its copyrights, such as the right to distribute, such as the right to reproduce, to Jukin, and then Jukin has those rights. It stands as the position of the copyright holder because it holds those sticks in the bundle of rights. So I don't think it changes things up. Thank you for what you do. You're very informative and entertaining. Keep up the awesome work. Oh, see, you cheated. I don't want to read comments live. See, that just looks narcissistic, but I very much appreciate it. So at Hoeg Law, I appreciate it. So I think that's it. If nobody else has any comments, I very much appreciate everybody kind of participating here. This worked a lot better than I even thought it would. And maybe we will do this more and more often. I certainly think it is useful to kind of get a little bit deeper into the weeds, respond to some people's comments. It's certainly easier than me typing up all the responses and comments to the YouTube videos themselves. And I do like to have this interaction with people on the live chat. Okay, we've got one last one, and then I'm legitimately saying goodbye. At Hoeg Law, my issue is the $1,500 is part of the contract between original content maker and Jukin Media, yet third parties are getting this bill. Are you liable as a third party to a contract you didn't sign? You're liable for the infringement. So regardless of where that right might have wound up, if we assume, again, we've got a lot of assumptions on whether or not Jukin has all those rights. If we assume that they do have all those rights, you will be liable for the infringement of those rights, and Jukin can and go ask for damage money from you. And that's the situation with copyright. Okay, I promised I was done. I very much appreciate everybody's participation. If you like this video, if you like the video on Friday, like, subscribe, tell people that we are doing this on Virtual Legality. Check out the other YouTube lawyers that I mentioned talking about these things. I think there is a congressional hearing on COPPA and YouTube this week that you should definitely check out if you're interested in law and virtual legality in general. Otherwise, we are talking about these things all the time. I very much appreciate everyone's participation, their participation in the comments to the video on Friday. I'm always very happy to see this level of engagement on what can be very, very technical issues. So if you watch this on YouTube in archive or live with us tonight, or if you wind up listening to it in its podcast form, which I'm not sure I will make on this, but we will decide, I very much appreciate it, and I will catch you on the very next episode of Virtual Legality. Thanks, everybody.